IRS audit interviews often sound informal. Watch out if an agent says, "Let's clear up a few things, shall we?" But IRS interviews can decide the direction of your entire case. What you say and how you say it can turn a routine audit into something far more serious. The IRS doesn't interview you just to understand your story. They interview to test your credibility, identify your sources of income, evaluate your record keeping to determine if the books have been cooked, spot inconsistencies in your written and verbal representations. They are listening for patterns, not explanations. Many taxpayers walk right in trying to be very helpful and walk out having created risk of criminal tax prosecution, whether they wanted to or not. How talking to the IRS can create criminal tax exposure. Many criminal tax cases do not start off as criminal. They start off as civil, and they escalate because of taxpayer conduct, over-explaining, guessing at numbers, speculating, contradicting written documents. Eventually, the IRS is going to compare your interview statements to bank records, third-party reports, and accounting data. Inconsistencies can look like criminal tax intent, even where none existed. IRS interviews are especially risky when there are missing or incomplete records, there's unreported cash activity, there's unreported income of any kind, there's aggressive or unsubstantiated deductions, there's untaxed, unreported offshore income, unreported taxable cryptocurrency. At that point, the audit can quietly shift into an eggshell or even a reverse eggshell audit. That is where criminal tax exposure starts to appear in your fact pattern. Let's talk about your rights under federal law. Federal law recognizes that IRS interviews disadvantage taxpayers. So, under Internal Revenue Code Section 7521, you have the right to representation. You can require the IRS to go through your representative. You can pause an IRS interview to consult with your representative. You can even record in-person interviews with proper notice. I don't think it's a good idea, but you can. These are not technicalities, they're strategic tools when used correctly. You should consider declining, delay, or limiting an IRS interview when criminal tax exposure may exist. The IRS starts to focus on your intent. You go in, you find out you're unprepared. When documents can speak for you instead of you doing it. When a representative can answer instead of you doing it. Declining does not mean being uncooperative. It means being strategic. The IRS already has summons power. If your testimony is truly required, they will summons you to talk to them. Listen, don't ever take the Fifth without using an attorney. It's not just as simple as invoking in the Fifth Amendment. It's not a casual decision. It must be done question by question, under a coordinated legal strategy, with summons enforcement risk in mind. Handled poorly, claiming the Fifth can escalate your case. Handled correctly, it can protect you. Listen, no CPA should be involved in advising you on your constitutional rights. That is plainly the unauthorized practice of law. IRS interviews are leverage points. They can move an audit along or inject it with criminal tax risk. If the IRS requests an interview, and criminal tax intent may be an issue, you should not manage that alone. Or, whatever you do, don't involve the original preparer, who has conflict of interest with you and may wind up becoming government witness number one against you. At the tax law offices of David W. Clausing, we treat interviews as strategic events, not courtesy meetings. Call 1-800-681-1295 or visit clausing-associates.com to schedule a confidential, reduced-rate initial consultation today.